Today we're going to talk about when it becomes necessary to involve a third party in helping you to resolve a dispute. So we're going to assume you've used your very best principled negotiating skills, but for whatever reason, you have not been able to come to a resolution with the party you've been negotiating with. Today we're really going to be talking about business disputes and bringing in a third party to resolve a dispute that you haven't been able to resolve on your own. With respect to personal disputes, if people involved in an attempt to resolve a personal dispute are unable to reach a resolution, they can turn to third parties as well. They could turn to a therapist, they could turn to a counselor, they could turn to a religious figure. But those aren't things that we're going to talk about today. We're going to be focused solely on in a business setting when it becomes necessary to turn the resolution of your dispute over to a third party for assistance. The first way of bringing in a third party to assist in the resolution of a business dispute is to pursue traditional court proceedings. And that means filing a lawsuit or having some other person file a lawsuit against you or your company. Those lawsuits can be filed either in the state court system or the federal court system. And even though these two systems resolve different types of disputes, the fundamentals of how a dispute gets resolved are basically the same. In a court proceeding, the ultimate goal is to get to a trial. And at that trial, you will put on all of your evidence and make all of your arguments, and your dispute will be decided by a judge or a jury. During the course of those proceedings, up until the time that you get to trial, the case proceeds in what's called a discovery phase. And in a discovery phase, each party is allowed to find out all of the evidence and documents that support the other side's case, or perhaps support their side of the case. And the parties are allowed to do that by conducting something that's called discovery. And there are three basic types of discovery that parties to a court proceeding can engage in. First of all, the parties may take what's called a deposition of either the other party or third-party witnesses to the dispute. At a deposition, the lawyers, or a party, if you're not represented by a lawyer, is entitled to bring a party or a witness into their offices and to ask them questions under oath. It's a way to find out, when the case ultimately goes to trial, what these people are going to say at the time of trial. Parties may also ask the other side, the other party, to produce all sorts of documents that relate to the disagreement or the dispute. And they can also serve the other side with something called interrogatories, which are written questions that the other side has to also answer under oath. The purpose behind discovery is that it is intended that nobody has to be surprised at trial. That if somebody has thoroughly conducted discovery, they will know exactly what the other side is going to say at trial and what evidence is going to support the other side's case. One of the reasons of having discovery is that there's a hope that once each side discovers the other's case, there may be some efforts to settle the matter. That's a good part of discovery. Unfortunately, one of the bad parts of discovery is that it can be abused by either side, and there are very few limitations on these kinds of types of discovery abuses. And the discovery abuses are generally that you just bury the other side with all sorts of depositions, with all sorts of document demands, with all sorts of interrogatories, right? To just bury them in all this paperwork and proceedings, which has a result of driving up the cost of the litigation. Right? But we go through the discovery phase, we go through the trial phase, and then at the end of the trial, either the judge or the jury will render a ruling saying who wins and who loses. After there is a decision made at the trial level, the losing party has an automatic right of appeal to go up to another court that generally has 3 judges sitting on that court, who will review what happened at trial court and decide whether there were any errors made, and if so, to send the matter back for a new trial. Right? So this is a stopgap from a bad decision made by a judge. Right? Wrongly instructs the jury as to what the law is, makes their own errors of law. It happens all the time. So having this appeal backstop is a protection against errors that might happen at the trial level. The cost for entering the court system is generally imposed by the means of filing fees. So if you're going to file your complaint, you have to pay a filing fee to do that. When you file an answer, you have to pay a filing fee. Every time you file a motion, you have to pay a fee for filing that motion. And if you elect to have your trial by jury, you also have to pay a certain amount of jury fees. And it's through collecting these fees that the court system pays for giving you the right to have this trial before the judge or the jury. As the result of the way court proceedings are structured, they can turn out to be very lengthy and very expensive. And that's predominantly due to this availability of discovery during the court proceedings. So one of the drawbacks is, even though at the end you get your ruling having a third party telling you who's right or who's wrong, it can be very lengthy and expensive to get there. If you remember one of the first readings, we talked about 3 different ways of resolving disputes. One was resolution based on power, one was resolution based on who is right, and one was resolution based on interests. In a court proceeding, it is a resolution based on who is right. At the end of the day, there is an enforceable ruling saying whether you win or your opponent wins. So the rights are determined, and that is how the dispute is resolved. By the way, not all judges look as mean as this guy, but a lot of them do. I thought it was very funny when I found this picture because he actually reminded me of a lot of judges I've appeared before. As a result of the fact that court trials, court proceedings can be very long and expensive, a different type of proceeding that also determines disputes based on rights developed as an alternative to a court proceeding. And that alternate method of resolution, which we call alternative dispute resolution, is what is called arbitration. Arbitration is when the parties step outside of the traditional court system and they hire someone to be a private judge. That person is known as the arbitrator. Now, the arbitrator could be a retired judge, someone who's stepped back from hearing court cases but doesn't want to retire altogether. It could be an attorney, and the arbitrator could also be some other professional with particular knowledge in the field of the dispute. Arbitration became a very popular alternative when the court system was very backlogged. When I first started practicing law 35 some or more years ago, a case that was filed in the court system did not even come to trial until at least 5 years after it had been filed. So you have your dispute and you go through this extensive, lengthy waiting period until you can finally get your day in court. And no case got to trial sooner than 5 years. That's what made arbitration very attractive at this time. It was intended to provide a much faster and less expensive dispute resolution system. How was it faster and how was it less expensive? Well, it was faster because for the most part, unless the parties agreed to it, there was no discovery. Or if the parties agreed to some limited form of discovery, but that whole delay and expense that is created in the court system because of depositions, document demands, interrogatories, doesn't exist with arbitration. Also in arbitration, there is no right to a trial by jury. Your trial is heard by the arbitrator, and the arbitrator is the one who makes a binding decision. So the arbitrator does the same thing that a judge does. The arbitrator listens to all of the evidence, takes the testimony, reviews the documents, and makes a decision about as to who is right and who is wrong. Once again, this is a form of dispute resolution based on who is right. The decision of the arbitrator is binding on the parties, and the winning party takes the arbitrator's award to court and asks the court to then enter that award as a binding judgment. And the courts are set up to do that, and then the winning party may enforce the arbitration award just as if that party had gotten the judgment in the court system. The other thing that makes arbitration more faster and less expensive is that there is extremely limited right of review of the arbitrator's award. The merits of an arbitrator award are not reviewed by a trial court or a court of appeal. And that is one of the big risks of arbitration. If your arbitrator makes an error of law, they're just wrong on the law, and they issue their award based on that, you're pretty much stuck with it. There's not too much you can do about it. Basically, the only time you can get someone to review what the arbitrator did is if the arbitrator exceeded the arbitrator's power or the arbitrator engaged in some kind of fraud or something. But if not, the arbitrator just makes a legal error, you as a party are stuck with that legal error. There is no backdrop like we have in the court system with the Court of Appeal. Backstop. As arbitration became popular, people did discover that there were some problems with arbitration, in addition to the fact that the award of the arbitrator is basically not reviewable. First of all, the arbitrator is paid for his or her time by the parties. Rather than paying the filing fees like we pay in the court system, the arbitrator has an hourly rate that's usually divided between the parties. And that hourly rate for a good arbitrator can be quite high. Sometimes it's $500 an hour, sometimes it's $600 an hour. There are some arbitrators who charge as much as $10,000 a day. So as a result of this, having to pay not only your lawyers, but the arbitrator, for the arbitrator to hear your case, this makes it a form of dispute resolution that is really only available to those who can afford it. So people without financial means don't have the opportunity to take advantage of this. It is really kind of dispute resolution for the elite, for the financially elite. Another problem that has developed with arbitration is that arbitration provisions are being placed in contracts where one party has greater economic power and business sophistication and pretty much forces an arbitration agreement on the parties that they're dealing with. So for example, your credit card company. I can guarantee almost all of you in your credit card agreement have agreed to arbitrate any dispute with your credit card company. Banks, the same thing. Whatever, when you open your deposit account, you've probably signed an agreement that says any dispute, you agree to arbitrate it. So what does that do to you? First of all, it gives up your right to a jury trial. It requires you to have to split the cost of an arbitrator if and when there's a dispute. And you lose your right to appeal if a judgment isn't in your favor. All those rights are given up before you really know what you're giving up. Finally, the last problem with arbitration is that judging became a business. When we go to the court system and we appear before a judge, that judge is paid by the state or federal government. The judge is not paid by the parties, and the judge gets paid the same regardless of how many cases he or she hears. With arbitration, however, it became a business where these retired judges, the lawyers, other parties, bill for their time to resolve these disputes. The more cases they get, the better. And so while most arbitrators do try to be fair, there has been either a conscious or many times an unconscious bias of the arbitrator to favor those parties who are going to bring the arbitrator more business. And who are those parties? Those parties tend to be the larger law firms. That if the arbitrator starts ruling in favor of the clients of the larger law firms, the larger law firms are going to be bringing more and more business to that arbitrator. So whether this is something that's done consciously or unconsciously, there tends to be a bias of the arbitrators. At times, there's plenty of arbitrators who are totally fair and unbiased. But at times, they do tend to favor those parties who can keep bringing them business. The next type of dispute resolution that we're going to talk about involving a third party is a type of resolution that is interest-based, not a resolution based on who is right. And this form of alternative dispute resolution is called mediation. Mediation is very different from a court proceeding or an arbitration. With a mediation, the parties who are involved in the dispute hire a neutral third person to see if that person can assist them in helping them find a resolution to their dispute. This is a process where the mediator doesn't make any decision that's binding on the party. The mediator just tries to assist the parties in reaching an agreement between the two of them. Participating in mediation is a voluntary process. The parties can decide to do it or not do it. If they decide to start and they decide they're not happy with it, they can end it. So it requires voluntary cooperation on both sides of the dispute. One of the things that's very appealing about the mediation process is that everything that happens in a mediation is confidential. A party can't use what was said later on in a court proceeding to try to hold it against the other party. There are special rules of evidence that say anything said and discussed in a mediation cannot be introduced later on in a court of law or any other proceeding. And the reason for these rules is the law is trying to encourage people who participate in mediations to be open and honest with each other. They can't really do that if they're involved in a lawsuit or if they're involved in an arbitration, but they can do that in the context of a mediation. Mediations are conducted in a number of different ways. I happen to be a mediator and been trained to be a mediator. Depending on the dynamics between the parties, sometimes the mediation is conducted with everyone sitting in the same room together. In the mediation that you're going to watch next week, you're going to see that technique being used, where both parties to this dispute sitting very close to each other, very close to the mediator, and working side by side. Sometimes that doesn't work so well, and one of the areas in my experience that tends not to work so well is when lawyers are involved. Because for some reason, lawyers who are on opposite sides of a case don't like sitting in the same room with each other. And if you have one of those dynamics as a mediator, you use something that's called shuttle diplomacy. And that is where the parties sit in different rooms. They're not sitting in the same room together. And the mediator goes from one room to the other room, back and forth as a diplomat, being shuttled back and forth. Whatever form is used, whether everyone meets together in the same room or whether the mediator uses shuttle diplomacy, going room to room, a mediator uses many of the same skills that we've learned when we've learned about principled negotiations. They use things like active listening and many of the active listening skills that we've learned. One of the things I'm going to ask you to do when you view this sample mediation next week is to try to notice how many active listening skills the mediator is using as she works with the two parties who are having the dispute. Mediation is a very effective way to resolve a dispute when the parties both are hoping to have a resolution and when they're not at the far opposite extremes of the issue and just being incredibly stubborn and can't budge. For those parties who are willing to still try to see if there's a resolution, even if they haven't been able to do it on their own, and work with the mediator, mediation is successful 60 to 80% of the time. So if you have a dispute that you haven't been able to resolve on your own, and it looks like you might be headed to litigation or arbitration, think carefully about whether you first don't want to try to involve a mediator and seeing if the mediator can help you pass the bumps in the road that you couldn't surmount on your own to help you reach a resolution. If the mediator succeeds and the parties do reach agreement, as I say, the mediator doesn't make a decision, a ruling, but what the mediator will do is help the parties prepare an agreement that reflects the agreement that they reached, and then they will both sign that agreement. So the result of a mediation is not a judgment or an arbitrator's award, but it is an enforceable private agreement between the parties that the mediator has assisted the parties in reaching. Mediation has become so effective in avoiding litigation, or if a case is in the middle of litigation, of ending that litigation, that more and more parties I've seen in my practice are building mediation clauses into their written agreements. So the parties will say something like, in the event of a dispute that we aren't able to resolve on our own, before a party may file a lawsuit or perhaps seek arbitration, depending on what you've agreed to, we agree that we will spend at least 8 hours with the mediator trying to see if we can't resolve our dispute short of having to file a lawsuit. And we agree to split the cost of the mediator and whatever else might be in there. Right? But more and more parties, particularly in the entertainment industry, I'm seeing it, build these mediation clauses into their agreements to give the parties one last shot with the help of a third party to see if they can't reach a resolution. And certainly, if you are those 60 to 80% of the people that can, you've avoided the costs and uncertainty of litigation or arbitration. So as you can tell, I'm a big believer in mediation, partly because I am a mediator, but the reason I became a mediator was because I was such a big believer in mediation. Now, there's a few other types of third-party involvement that you can use if you are unable to resolve your disputes between the parties. And we want to talk just about a couple of those next. Sometimes parties will use what's called a summary jury trial. And this is often used when, as we've seen, parties can be overconfident in their position and overconfident in their chances of winning. So the parties bring in a mock jury. Right? There are companies that will help you do this. They'll bring in a certain number of jurors and they'll put on a shortened version of their case. They'll argue it to the jury, put on their evidence to the jury, and then the jury will go and deliberate and they'll deliver their verdict, but it's not binding on the parties. And this sometimes is a good thing to do, as I say, when one party or both parties are so overconfident in their position that they've got a slam dunk case they're going to win at trial. Right? Maybe that's true, and maybe this mock jury will confirm that, or maybe they'll get a big surprise and find out that they've got more holes in their case than they knew about. So that can sometimes be an effective way to bring the parties around to be more realistic about what their demands are. Another procedure that's available, also involving a third party, is what's called a mini trial. And rather than a mock jury trial, this is a trial before someone who poses as a judge. So it's some neutral person, third party, who comes in. Again, a little mini trial takes place where evidence is presented, arguments are made, and then the advisor offers his or her opinion about the case's likely outcome in court. Once again, this can be an effective technique to use when the parties are both overconfident, or one party is overconfident in their position. To have a chance at a pretend trial and get some feedback about what the likely chances are when it goes to a real trial. Finally, another option that's available is what's called an early neutral evaluation. This is where a neutral private attorney with experience in the field of the dispute comes in and reviews both parties' cases. What evidence is there? Now, it's not done in the form of a trial. It's done in a more informal review. But each side presents their case, their evidence, their arguments to this neutral private attorney. And then the private attorney gets back to them and says, here's what I think about your case. Here's where I think your strengths are. Here's where I think your weaknesses are. Here's the risk you're going to face if you go to trial. Once again, to get some third-party feedback to maybe get the parties back together and speaking to each other, hopefully getting them to come to a resolution of their dispute on their own. So, court proceeding, arbitration, those are resolutions based on rights, where binding decisions are made that the parties are stuck with. Mediation and these three other options that I've just spoken about, these are non-binding ways to try to get the parties back on track to reach their own private resolution that will then be enforced by an agreement between them. All of these types of third-party resolutions have their time and place. Depending on your circumstances, it may be you have to file a court proceeding, or it may be you have to go to arbitration. Other situations are ripe for mediation, or some of these other options that we've just talked about. It just depends on your particular circumstances. But know that these options are out there if you have not been able to reach your resolution on your own.